So, the officer, what's your goal? Your goal is to have him work with you and wind up saying that at the very worst, he had reasonable suspicion, that there was no impairment. I can usually get an officer to tell me that from the moment the overhead lights came on to the moment that my client pulled in safely next to the curb, there was no circumstantial evidence or other facts indicating that my client was having problems with divided attention. I can shorten it, I can long it, I don't know, it just depends on how I feel, but I can get him to say, I had a checkpoint case in Ventura, and I love Ventura. Why? Because I get to go to trial, and I go from 8:30 in the morning, I go to 4:30 or 5, and we bang it out, and the jurors will listen. I won a .26 blood with bad driving, which became good driving through cross. I won a .15 blood with no driving defense, and I won a 1-1 checkpoint. And on the checkpoint, it came to me, we evolve as lawyers, it came to me, my God, they've got no impaired driving. And so what they do, I spent half an hour on the topic of impaired driving with divided attention, with mental impairment goes first, with you expect to have impairment in the ability to monitor the environment and use your steering and to use your judgment and all the bullshit that they give us when their expert comes in through the officer. And in this case, the lady drove in and the officer then directed her through the cones. So I had to talk about cones and coming in the curb and I don't know. I spent 15 minutes talking about how she drove on the checkpoint. No mental impairment. And we would expect when their expert comes in, oh, let me stop. I saw Daryl Jennis, one of the great warriors. He's sitting over there in his flight jacket. So I got this guy named Trevor Booth. I don't know Trevor from a hole in the wall. I don't get up there that often. But when I first met Trevor, I looked at his resume and I see UCLA. So of course, because we're all in it together, right? Trevor, I went to you. Oh, you went. Okay, great, Trevor. It's wonderful. So I'm sitting with Trevor and I'm talking about UCLA and I'm talking about some guy represented on the basketball team and we're shooting the breeze and kibitzing and having a great time. We were just becoming embryonically the best of friends. Janice walks in and says to me later, Artz, I've never seen anybody be friendly with the experts, or words to that effect. The point of it is we don't have to take them on and try and kick their ass, because it doesn't work. We can make our points. All right, so in that case, of course, the expert came in and said at the time of the driving, like I was a 1.2 or 1.3, whatever, the 0.02 higher. And, you know, there's part of the wedge. It's so because everyone at 0.08 and most at 0.05 have these problems of divided attention and inability to drive, and your facts are such that you don't have it. Folks, all your technical stuff about, oh, it didn't comply with the 15-minute observation period, or, oh, preservative, all that's great stuff. You didn't invert the vial. Great, you gotta have it. But there, I believe, is the real essence of the disconnect, the real essence of the not guilty, of not proved. They don't have mental impairment. Mental impairment goes first. It's not here in this case. The right thing is a not guilty. Okay. Field sobriety tests. First of all, minimize them, right? They're indicators only. I haven't had much success. Some guys had keeping them out because of foundation. But, you know, from a standpoint of field sobriety test, we can always get anxiety and nerves. We can always get, they don't check for that. We can always get it at worst probable cause. Field sobriety tests don't bother me. When clients are interviewing with me, I cut them off right at the chase saying this is all about chemistry. I don't want to hear about your field sobriety test. God forbid we have to go to trial, but if we do, we'll spend 45 minutes up there with charts showing all the things he did right. But field sobriety tests, that's not going to kill us. Okay. You know, they don't relate to driving ability. I saw one of the emails here where one of the guys challenges the prosecutor during an opening statement about that, and that's great. I like the fact that when my client's doing field sobriety tests, not only is he anxious and nervous, but that he's got an officer who seems very determined, and he was worried about maybe going to jail and who he's going to be incarcerated with. I mean, those are things that he's thinking about while the officer is telling him to do stuff. Okay, so now comes their chemist. And the trial I lost in part in addition to my ego getting in my way and thinking it was won because of I had some evidence that they didn't have preservative. Well, their evidence wasn't. It's in there because the manufacturer puts it in there. My evidence back was you don't test, and there's 14,000 vials that your crime lab bought last year, and you didn't test preservative for one of them. 10? Okay. Thanks. So anyhow, in the trial I lost. I had the issue of preservative. I had the issue of no refrigeration. I had a study admitted that said if you don't have refrigeration, even with preservative, you can go up by 0.06, 0.07. I had a 0.10 blood test. I mean, come on, I had no impaired driving. And on the expert, because she gave me, she being the prosecution expert, gave me that she didn't know whether my client was impaired or not at the time driving. She didn't know whether my client was appointed or not. I didn't call my expert. I'll never do it again. I'm going to call my expert if I have one. And here's why. I think jurors decide things on how they feel, and I think if there's gaps, they fill out the gaps. Otherwise, I should not have lost that trial. Not on the evidence. Not on the evidence. So, you know, with cross-examining the expert, 2 trials ago, I had a judge stop my cross. Unbelievable. Never had it happen. I'm crossing this witness from the crime lab, and she's being evasive. I'd ask her about whatever, absorption. And she'd give me answers that, of course, favorable her side, and not narrow my questions down to, well, isn't it true that Dr. Dabowski wrote in a study that absorption can occur up to 2 hours? Yes, but he changed it. So I start going to the judge after about 5 of these. And I said, Judge, in front of the jury, I said, hey, Your Honor, would you please instruct the witness to answer my questions? To answer them directly, and to answer them yes or no. And I started forming my questions in a way precisely yes or no. And she wouldn't do it. Judge called a timeout, put us in the chambers, took us back and said basically to the DA, you tell this witness to start answering the questions and answer them directly, or I'm holding her in contempt. Why? Because I went to the judge 4 or 5 times saying, Your Honor, would you please instruct nicely? Would you please instruct this witness to answer my questions? The judge told the DA that, and that witness then started giving us stuff that's very helpful to the defense, stuff like you heard from the expert here. And you don't need to be an expert. What I learned from the thing today is the, I have it written down, but the FLIC study, or the FIC study, or whatever it is, I've got it down. I will know it by the next trial, but that's good stuff. Give me a formula on that, and get up on the board with the charts. Oh, I didn't tell you. Opening statement, opening argument, what do you have to do? Have to do. You have to have a timeline, right? When your guy got up that day, he's a hard-working guy, you have to have what he worked, and when he left home that night at whatever time it was. You have to have your drinking pattern down if you're going to put them on, if you're going to reveal that. Sometimes no, most of the times yes. It depends on your facts. You have to figure out what's going to sell. And then why not a driving chart? Why not say to them what your argument's going to be? Ladies and gentlemen, the evidence is going to show you my client was somewhere around a 0.05, 0.06, maybe max 0.07 at the time of driving. The evidence will show you that my client was in the absorptive phase. Here's a blood alcohol curve. I'm up doing blood alcohol curves through an opening statement. I already have it drawn, but why not? Objection! They hate it when we do that. And if they hate it, something must be going on good for us if they object so much. So in your opening statement, tell them what the evidence will be. Why not draw a blood alcohol curve? Why not put your guy, my guy started drinking at 8 at night, the driving was at 12, the blood test was at 1, you're going to see that at the time of the drive, and it's a 0.10, I tell them an opening statement. Why? Because I'm trustworthy. I tell them what the blood test results are. I tell them that the POS test is coming in. I don't hide a thing in it. Why? Because my client's not guilty, and that's what they got, but it's not enough. It's just not, you'll find out as we go down this trial, you'll find out that based on all the evidence, they cannot prove my client was a 0.08 or higher at the time of driving. You will not see mental impairment. I mean, you have to know that you have these facts before you can say it too much. But so with the expert, ask precise questions, get yes or no. Do you agree that, whatever. Okay, on defendants, 5 minutes?
5 minutes.
Perfect. Okay, on defendants, check out the internet. If you got a guy, like I did in the Inglewood trial, who's got on the internet pictures of him drinking lots of booze, rum and coke, Captain Morgan, you know, running amok. Maybe you suggest to him that he takes that shit down before you get to trial. I don't know. I mean, you know, the DA came in with 10 photographs and I kept them out, but whatever. Character witness. Bartel and I talked about this. If you have a first offense so they can't bring in, would your opinion still be the same if you knew about his 5 priors type questions? If you don't have any priors, character witnesses, how cool is that? I'm hearing my brother over here say that's great, and it is, because you can bring in a nice looking man or woman. I've known this guy for 20 years. He never drinks to excess. He's the most honest, reliable man I know. I trust him with my life. Question. Well, would you trust him with your life if he was a 1.5 blood weaving all over the freeway? Well, that doesn't sound like him. That would be interesting. Question back then. Here's how you fight their character hypos. How about if he was an 06 but the measurement was bad because they didn't follow proper procedures on the blood test? Or whatever you got, right? How about coming back with, if you want to ask him some questions that hurt me, well, let me ask 10 more that make it so that it's a not guilty is the right thing to do under the facts of this case. So you got, you know, you got to, let's create out here. We're drawing the script up. Don't go their script, go your script. Unless you want to lose. Okay. I'm going to give you some last thoughts on jury. I've got about 2 minutes, and here's the deal. I don't think that jurors decide these cases on all the factors. I think we have to have them. I think they put in their own experience and backgrounds. The trial I lost, Asian American young man, short hair, didn't talk. He was a poor person. He was nodding his head in lockstep with the DA during closing argument. God, it still hurts me. I fucked that case up. I gotta say it. I did. I had it, and I just let it go. And it's not right to my client. I mean, I can stand up here and take the hit. I do pretty good, but anyhow, jurors decide this stuff not on all the stuff you give them. So the only way, I'm going to close with this, the only way you can win these trials and get 12 zips, I think, is not technically, is making them feel good to vote for not guilty. You'll be doing the right thing. When you leave this courthouse, you can hold your head high. And the last thing I say to the jurors before I walk away and hand it to them, when the tears come in my eyes, is something along the following lines. Ladies and gentlemen, Mr. Smith trusted me 9 months ago when he was arrested, when he came in my office and told me he was not guilty. He gave me this case. He trusted me to go to court and do what I can. I've had this responsibility for the last 9 months. This is the biggest thing that ever happened to me. I'm going to now turn this case over to you to do the right thing. Please, do the right thing, and he thanks you, and I thank you very much.